very important topics facing all of our countries today. The topic that we will focus on in the conversation at hand will be toward the rule of law in Eurasia. And so we have 4 really interesting presentations lined up for you. Before we start, let me just mention a few things. First of all, I want to thank Carnegie Corporation of New York, as well as George Washington University and the Institute for European, Russian, Eurasian Studies and the Elliott School of International Affairs for their support for Ponars Eurasia, including this program. I'd also like to encourage people to take a look at our website if you would like more information or would be interested in additional analysis. That is ponarseurasia.org. Basically these presentations frequently either are based on or result in a subsequent publication of a Ponars Eurasia policy memo. And so you can find those there, and I might mention it when introducing the individual speaker. But note before we start is that I will gather questions, people in the audience, to address to the so I won't necessarily go in the order that I see them. I'll try to group them by the possible, or at least distribute them. They are relatively evenly distributed to the different speakers. So I encourage you during the session to send your questions either to me directly through the chat or post them to everyone. So without further ado, let me introduce the first speaker today, and that will be Dr. Emil Beck, Jiraya, who is teaching fellow at the OSCE Academy in Bishkek, Kyrgyzstan. And he will be speaking on the subject, Justices for Democracy, the Kyrgyz Constitutional Chamber's fledgling guardianship of democracy. So Emil, the floor is yours.
At least both you and the name of Marlene, I didn't get to see Marlene herself, and everybody else. It's been a challenge to keep up with the busy schedule of Ponars, but I'm very happy to be now together and joining this panel. And it's a great panel title, Toward Democracy in Eurasia, Toward Rule of Law in Eurasia with a question mark. And I think in Kyrgyzstan, as we speak today, this could not be any more salient. And I titled my paper already back in March, or was it even before, whenever we were planning for this, Justices for Democracy with a question mark, and Kyrgyzstan's Constitutional Chamber as a fledgling guardian of democracy. Now, as I speak today, I must mention in this unfolding news, Kyrgyzstan's the Constitutional Chamber, the institution that I'm going to talk about, will have the final word, I think, on the constitutionality of what's being put forward by the de facto government today and de facto parliament for a postponement of the parliamentary elections and going for a constitutional referendum before the parliamentary elections. And a group, a leader of a party and former member of the Constitutional Chamber, has filed a complaint on the constitutionality of this move. Now, that having said, and we don't know how that decision is going to be made, how the Constitutional Chamber is going to handle it. Now, generally, judiciary's role to the relation to democracy is generally a much contested, debated subject, and at least it can be said generally to be in tension with democratic politics. In recent decades, there has been quite a number of major works and streams of work actually debating and discussing the roles of especially constitutional courts in relation to democracy, some arguing that it is an undemocratic, unelected institution that has been taken over the political democratic process, whereas others have been arguing to the contrary, that they have been institutional bulwarks to democratic passions and as constraints to the democratic passions, as it were, to use Holmes's language. Now, in the Eurasian context, of course, there has general impression has been that the courts in general, the judiciary systems in general, and the constitutional courts in particular, have been mostly rubber stamps devoid of any autonomy or agency in deciding the fate or the direction of constitutional as well as general political processes. Now, in the case of the young constitutional chamber of the Supreme Court of the Kyrgyz Republic, that's the full name, remarkably enough, the judges of the constitution of the court have quite consistently argued in defense of key democratic institutions and mechanisms. In the ever-shifting trajectory of democratic politics in the country, the record of the Constitutional Chamber has turned the court into a promising agent of commitment of the country, or recurring recommitment of the country to democratic principles. This role is still only a promising one, hence fledgling, and it behooves different other stakeholders, the civil society, the international development community, and of course, the political actors committed to democracy in the country, to lend open and persistent support to the work and independence of the court. Briefly about the background, the Constitutional Chamber was established with the adoption of a new constitution in 2010. It replaced the disbanded Constitutional Court that was deemed to have completely discredited itself as a rubber stamp for the ruling presidents, first of Askar Akayev and then of Kurmanbek Bakiyev. The compromise was that there was one side arguing for not having a constitutional court at all, instead to have the Supreme Court to deal with the constitutionality issues, and the other side arguing that a new constitutional court needed to be put forward. Now, the compromise was to establish the Constitutional Chamber of the Supreme Court of the Kyrgyz Republic to be charged specifically with interpretation and judging on constitutionality. It was filled. It took about 3 years, so it was filled and got active in the second half of 2013, and since then it has been remarkably active. And compared to the numbers of cases that were dealt by its predecessor, the Constitutional Court of the Kyrgyz Republic, it was many times more active, with an always complete docket of cases still pending to be considered. And it has been deciding, indeed, the cases with relevant sort of substance and not just rubber stamping, as it were. It was, as an institution, it was a particular, it was an element or one of the outcomes of a particular state of balance in 2010, as I and three co-authors argued in another article some years ago, that it was only possible to establish this sort of an institution because there was a state of general political balance in 2010, with no particular institutions such as typically the presidential office or the parliament, as one could imagine, dominating over the playing field. Now, there were a number of, among the hundreds of cases and decisions or opinions, etc., the acts of the Constitutional Chamber, there were a bunch that took up particular attention and became very important evidence of what kind of a jurisprudence it was developing. On government versus parliament, for example, there was a major decision in 2014 where the Constitutional Chamber was asked by the Ministry of Finance of the Kyrgyz Republic to resolve an issue relating to the competence of the Budget Committee of the Parliament to dictate or to require the government, the executive that is, to allocate certain funds here, certain funds there, basically earmarking funds, and in what would be the pork and barrel equivalent in the Kyrgyz case. The Constitutional Court Chamber decided in favor of the executive, of the Ministry of Finance, making the argument specifically on the premise, on the principle of the separation of powers. Later in 2014 through 2015, there was another major case that decided by the Constitutional Chamber on the constitutionality of several decrees by the provisional government after the 2010 April Revolution, or what has been called the April Revolution here. And it was a very expectedly very controversial issue, and it was very difficult to predict how the chamber would be deciding. On the one hand, of course, if it were to be found unconstitutional, all of these decrees, then so many things would just be in suspension after several years since those decrees were passed. Now, it resolved it introduced a rather controversial argument of a political expediency or special times, and it argued within its own competencies, I guess, for what I think it would be called times outside of constitution, not non-constitutional but extra-constitutional situation, in which these sorts of legal decisions would be accepted. And the Constitutional Chamber essentially said it was not for the chamber to decide on the constitutionality of these decrees, thus essentially leaving those decrees intact, but then, importantly enough, providing that the government, to all the complainants, to be restituted for whatever legally possible complaints they had by the government. That is, the government had to bring all of its previous decrees, all of the decrees of the provisional government, in correspondence to now legitimate constitutional body of legislation. There were several others, such as on the constitutionality of deputy groups within the parliament that were beginning to function outside of the formal party-based factions, on the constitutionality of the referendum on constitutional changes in late 2016, and on one of the most recent and very interesting cases on the constitutionality of stripping the privileges of ex-presidential privileges of President Almazbek Atambayev. And that case, the latter case, was decided almost to the day 1 year before. And it was indeed that decision that particularly gave me the interest, the curiosity to look into the role that this chamber could play. Now, overall, in all of these and a few other decisions that came across, became important, the Constitutional Chamber showed an unusual, for the Kyrgyz constitutional practice, but usual, of course, for the United States Supreme Court or many other, the German, more established constitutional judiciaries in democratic societies, manner. The level of reasoning and the manner and the style of reasoning that was being given, passed on with every decision. It was quite surprisingly, it was devoid of the formalistic legal language that would be usually met in typical court decisions, but rather given to either theorizing or turning to other countries' decisions as precedent here and there when relevant. And as a result, providing the kinds of decisions that really elicited a much more serious handling, a much more serious engagement with the questions that were brought before the chamber. Of note were also something that were almost never met or paid attention to in the past, which were concurring opinions and dissenting opinions, especially. And several members of the courts really began to develop their emplois, I guess, renommes, as very often dissenting sort of opinions. In terms of their input to democratic or re-establishment, reassertion of democratic principles, there were several important principles that the court repeatedly turned back in deciding different cases whenever relevant. One from earliest on, it was...
You need to be thinking about wrapping up, please. We're getting a little low on time.
Oh, yeah. Yeah. So the key principle that it has argued very well was separation of powers. Very well, I mean, in a sustained manner. The principle of separation of powers and how the Constitution has built that principle into the mechanism of how the government ought to function in Kyrgyzstan, and on that basis to resolve different disputes among different institutions. It was also about checks and balances, something that is typical to the United States constitutional jurisprudence, of course, but the court in Kyrgyzstan has been adopting that language and infusing that into the separation of powers discourse. Another was on the equality of rights, and especially equality of rights to participate in politics, equality of rights to exercise citizenship. And this came especially very clear in the case regarding ex-presidential immunities of President Atambayev. And lastly, to reassert very often within the bounds of the constitutional responsibilities, the burdens of responsibilities of different institutions. That is, which institutions, especially which branches, carry the most burden or more specific burden to them, and what that implied in relations to their competencies. Now, very quickly, why the Constitutional Chamber was possible to arise like this. One was, as I said, a very special circumstance of 2010 that allowed for entirely new constitution to emerge, de facto lustration happening among the Constitutional Court judges. And as a result, it was a very open, transparent selection process itself involving both the civil society and open active citizenry, the parliament, and the president. It was also enjoying a lot of international support by UNDP, the European Union, and therefore, thus gaining much greater transparency than otherwise it would be possible. And lastly, perhaps it was also because the nature of what Constitutional Chamber is asked to do, to decide on constitutionality of laws, is something that possibly lends its greater support to it being more independent, less subject to economically based kind of corruption of the institution as such, and keeping it away from the enticements of bad judiciary. Now, and all of these stand to be lost, and I come back in wrapping up to what's now in front of the court, which is to decide essentially on what the de facto government today has put its fate on, which is to go for a constitutional referendum in a snap sort of decision and to postpone parliamentary elections. On its face, so many constitutional lawyers, rights advocates today understand this is an openly unconstitutional move. How the Constitutional Chamber is going to deal with this complaint is going to be a litmus test. But in any way, I think I argue that Constitutional Chamber is one important fledgling institutional beginning that has deserved and continues to deserve both the support of the domestic and international stakeholders and interested parties. Let me stop on this.
Okay, thank you very much.
I can turn back. I really got a little carried away into the time.
No, very interesting.
Add some things later.
Okay, thank you very much. Yeah, so just a reminder to the other speakers, please try to keep your remarks to about 10 minutes so we make sure we have plenty of time for discussion. Next is Ivan Gomza, who is head of the Department of Public Governance at the Kiev School of Economics in Ukraine. And he will be talking on the topic of justice without a blindfold, the complex politicization of a notorious Ukrainian court. And he'll be talking based in part on a Ponar's policy memo that's been published earlier that you can find on the website, ponarsurasia.org. So Ivan, please take it away.
Good evening. Actually, yes, the memo was written a year ago, and since that time, much has changed, not my prognosis, but some new developments. And actually, I've integrated them into the presentation of today. So now I'm starting sharing the screen because I have a PowerPoint presentation, and I hope it will be helpful. So, okay, I hope you can see it.
Yes.
Very well. Okay, I'll start with the idea that the alembic of post-Soviet transition has questioned many conventional assumptions. It proved that privatization, for instance, created not a burgeoning middle class, what gave rise to a tiny cohort of wealthy oligarchs. Likewise, political competition in view of wider representation contributes to the advent of anti-liberals, like, for instance, Vladimir Zhirinovsky or Vladimir Mechia. It is yet another idea taken for granted that I want to discuss today, because for years, scholars and analysts preached that the independent judiciary is a prerequisite for successful transition. I have to admit that I myself full-heartedly espoused the gospel. So it was first with dismay and next with acute interest that I observed the developments within the justice system in Ukraine. Let me give you some flavor of those developments. In April 2019, a court declared void the nationalization of Privatbank. In September 2020, a judicial ruling forbade National Agency for Prevention of Corruption to probe into a conflict of interests within the Constitutional Court of Ukraine. In October 2020, Minister of Education, Shkarlet, sued the National Agency for Higher Education Quality Assurance for condemning the plagiarism discovered in his PhD thesis. Finally, just 3 days ago, I mean this Tuesday, another verdict stipulated that the head of National Anti-Corruption Bureau of Ukraine should be dismissed because his recruitment was unlawful. The cases I cited, they have two significant commonalities. First, they cripple the reformist thrust in Ukraine, either by incapacitating special agencies designed to promote good governance, or by abrogating public policies conceived to ensure state capacity. For instance, the investigations by National Anti-Corruption Bureau were endorsed both by OECD and the US administration. And Privatbank is the systematically imported financial institution in Ukraine, and its nationalization was praised by the International Monetary Fund as, I quote, a viable effort to safeguard financial stability. So that was the first commonality. The second commonality is no less important because all the verdicts I referred to, and you can observe on the screen, they were taken by the same legal body. Namely, this was Kyiv District Administrative Court, KDAC. And you could pick any politically significant and contentious judicial ruling in present-day Ukraine, and it is highly probable that you will see KDAC's signature on it. So to put it bluntly, KDAC abuses judiciary powers vested in its members to promote a distinct political agenda. In doing so, KDAC exemplifies the phenomenon of complex politicization of judiciary, and that is the notion I want to contrast with simple politicization. The latter, I mean the simple one, it describes a situation of a dependent judiciary when rulings are manipulated, when, let's say, power holders use their power to get a verdict they deserve, and when judges themselves, they are accustomed to political interference. And there is a huge body of literature which actually gives some valuable recommendations how to diminish that simple politicization. But I want, and I invite you to consider a rather frightening hypothesis. What if the very strategies to fight the simple politicization of judiciary, they backfire by stimulating the complex politicization? In other words, what to do when an independent judiciary morphs into a constellation of actors free from both public control and institutional checks and balances? That is the question I want to, let's say, discuss with you now, observing the case of KDAC. The case of KDAC offers actually a very interesting trajectory, and I distinguish 5 steps of the complex politicization of this court. The first one is the constitution of structural prerequisites for strategic action. In 2005, so 15 years ago, still elated after the Orange Revolution, the Parliament adopted the new Administrative Justice Codex, which placed adjudication of all cases against the Cabinet of Ministers, the National Bank, or any other national institution within the exclusive jurisdiction of KDAC. So from now on, 49 KDAC judges were vested with powers to overrule any governmental decision, from hiring an official to declaring a state of emergency. In 2008, the second step, that of political contamination, occurred. Here's a brief explanation. During the political infight between President Yushchenko and Prime Minister Tymoshenko, the latter appealed to Kdac to block a presidential decision. And dragged into the epicenter of power struggle, Kdac judges saw in political connections a necessary resource they thoroughly cultivated thereafter. The web of political context inevitably made Kdac politicized. Between 2010 and 2014, the court was mercilessly exploited by Yanukovych and his regime. They used the unique prerogatives of Kdac to justify many of their actions. And that was, we can say, the third phase, that of simple politicization. After 2014, it looked like nothing especially significant happened to Kdac. After some deliberations, Poroshenko kept the court and used it for political ends. However, just around this time, crucial group dynamics transpired, and an influential inner circle of 7 judges effectively took control over the Kdac machinery. As a result, a stable ruling coalition with a sense of unity and that of purpose emerged during the first phase of complex politicization. And from now on, the Kdac, being strategically situated as a gatekeeper between governmental policies and their implementations, it was ruled, the Kdac was ruled by people cunning enough to appreciate their autonomy. The efforts to promote an independent judiciary initiated after the Maidan actually further empowered the Kdac clique. So Kdac morphed into a self-serving agency, and since 2017, it is engaged in political struggle. And I want to be clear, it is actually irrelevant to ponder why Kdac opposes political reforms in Ukraine. We cannot rule out neither personal animosity to President Poroshenko and his political legacy, nor genuine abhorrence to westernization, nor long-lasting ties with anti-liberals like Portnov and Kivalov. However, I would like to argue that Kdac's opposition to good governance is actually strategic, because a kind of political turmoil and deficiency in state capacity is beneficial to Kdac because their political influence flourishes under these conditions. And moreover, a sense of independent agency seems to spill over the judicial system in Ukraine in general, thus making Kdac an early riser rather than an exception. And actually, the recent events I want to discuss now, they corroborate this interpretation. So I have to present you several key institutions of the judiciary power in Ukraine. State Judiciary Administration. It is an important, though often invisible body, for it manages properties and facilities of courts over the country. In January 2018, Head of State Judiciary Administration, Zinovy Holodnyuk, he sued his overseers who decided to dismiss him. The proceedings took place in Kdac, and the verdict blocked new recruitment that would have substituted Holodnyuk. In return, he appointed 2 members. He had that power, suggested by Kdac to the High Qualification Commission of Judges. It is a body which, according to the new law of 2016, a law which should have made the judiciary independent. So according to this new law, High Qualification Commission of Judges is responsible for the appointment of new judges for limitless terms. In July 2020, so several months ago, National Anti-Corruption Bureau, after tracking these developments, raided the Kdac headquarters and incriminated 12 Kdac judges alongside with Holodnyuk in an attempt to usurp power. And this provoked Holodnyuk's suspension just 2 days ago. Kdac judges, however, they proved to be more secure. You might ask, how? In order to strengthen judicial independence, the very same 2016 law annulled any role of either the executive or the legislative branch to recall judges. Now there is a special collegial 21-member body, it is High Council of Justice, and it is vested with these powers. However, High Council of Justice is packed with allies of judges from Kdac. And therefore, it is hardly surprising that High Councils of Justice first deplored the action by National Anti-Corruption Bureau as detrimental to judiciary independence. Next, it lamented the fact that 3 High Council of Justice members, all implied in dealings with Kdac judges, were invited to testify as witnesses. Allegedly, this, I quote, constituted an obstruction to justice. And finally, in September 2020, High Council of Justice plainly refused to suspend Kdac judges accused of high treason. This Monday, as you might recall the beginning of my presentation, Kdac verdict demanded head of National Anti-Corruption Bureau to leave his office. And I'm just like wrapping out it, other good governance agencies fare no better. When in June 2020, National Agency for Prevention of Corruption presented its anti-corruption strategy, the text explicitly cited a lack of integrity among High Qualification Commission of Judges and High Council of Justice members as factors of societal distrust in judiciary. High Council of Justice retaliated, condemning the anti-corruption strategy as unlawful and imperiling the independence of the judiciary. This Tuesday, the Constitutional Court of Ukraine declared most of prerogatives of National Agency for Prevention of Corruption unconstitutional. So in sum, a beneficial for judges stalemate of a weak state and inefficient checks and balances system has been preserved. The last slide and the last and maybe the most important idea. This constitutes a problem for when judiciary acts as a self-serving actor, it alienates the citizenry. The dynamics of distrust, you can observe it on the slide, on the screen. It's really revealing. We see a distrust accumulation. The judicial system is not only among the least trusted institutions in Ukraine. You see, it is second only to Russian media, but it has also accrued such figures much more dramatically than, let's say, other lawmaking bodies like police. And the fact that Ukrainians tend not to believe judges as much as they do not believe, let's say, MPs and the government, this fact suggests that the Ukrainians, they perceive the judiciary as a political actor. And there is a poll, according to this poll, 46% of respondents, they signalized that the reason they distrust the courts is the actions taken by judges. No less revealing is the fact that both the expert community and ordinary citizens, they deem liquidation of Kdac as necessary steps to cleansing the judiciary branch. Recently, just several days ago, once again, there was a petition to President Zelensky to abolish Kdac. The tragedy of the situation is that the complex politicization has already touched other parts of the let's say, body. So removing Kdac from the body might not, I'm afraid, suffice. So thank you for your attention.
Okay, thank you very much. Also very interesting. Next up, we have Maria Popova, who is Associate Professor of Political Science at McGill University, and she will be talking about the politics of corruption prosecution. So the floor is yours, Maria.
Thank you, Henry. Thanks to the previous panelists for the really interesting presentations. I definitely would like to hear more. My presentation today will actually be a little more theoretical rather than grounded in empirics. But I want to run some ideas by you about how we should understand the politics of high-profile, high-level corruption prosecutions. So let me also share a presentation with you. Okay, and let me arrange the screen in a way where I can see where I'm going. Okay, so let's start with the simple idea that the prosecution of high-level corruption is always a political tool because it produces political benefits. Who exactly draws these benefits and what they are varies, I would argue, along two dimensions. The first dimension is the transparency of goals, and the second dimension is the severity of legal consequences. So transparency here refers to the availability of reliable evidence that the prosecutions are primarily focused on what they're supposed to be focused on the task of evaluating whether corrupt acts took place, and if they did, applying anti-corruption laws accordingly. When transparency is low, corruption prosecutions are primarily instruments for achieving political goals other than reducing corruption, because of course, reducing corruption is also fundamentally a political goal. What are these other goals that corruption prosecutions could achieve? Well, the first one is very clear: the marginalization or outright removal of political competitors from the field, either by actually jailing them with a sentence, but also simply by ruining their career with the initiation of a corruption trial. It might not even end up in a conviction, and it would still achieve the political goal of hurting political competitors. A second goal of low transparency corruption prosecutions is to divert public attention away from other salient political issues. Fighting corruption is always a popular goal with the public. So in some cases, these corruption prosecutions could be just initiated as a way to divert attention from more serious problems. And a third goal of low transparency corruption prosecutions is to create what I call an anti-corruption Potemkin village for the benefit of international organizations such as the EU, the Council of Europe, IMF, World Bank, etc., all of which very often, constantly, in fact, advise countries with endemic corruption that they need to tackle it forcefully by prosecuting some big fish, sort of tackling the problem at the top. The severity of legal consequences is the other dimension on which corruption prosecutions vary. And it's a very straightforward point here that the outcomes of corruption prosecutions can vary significantly. Corruption rates, conviction rates can be high or low, and the convictions that do happen can be followed by slaps on the wrist for those convicted, sort of symbolic fines, suspended sentences, or they could be followed by serious jail time. Now, one thing I want to point out is that the severity of legal consequences doesn't necessarily correlate with transparency. We can have earnest prosecutions that end up in acquittals. We can have, of course, trumped up charges that end up in severe sentences, and anything in between. So here is sort of the requisite 2x2 that we can have of the two dimensions. And the different sort of configurations of corruption prosecutions that we have according to this variation. So first, I'd argue that when transparency of goals is low and the legal consequences are also modest, we have two variants of this. The first one is a Potemkin village anti-corruption campaign. Basically, this is all of the cases are initiated as a way of showing international organizations that something is being done about corruption. But in fact, everybody knows that none of these will end up, none of these prosecutions are really pursued seriously. None of them end up in convictions. There are basically no legal consequences to the people charged. And we have this situation going on for the last about 15 years in Bulgaria, as Bulgaria is under pressure from the EU to show that they're investigating and prosecuting corruption, but in fact, nobody is getting punished. Tons and tons of cases are being opened every year against very high-profile defendants. In fact, Bulgaria has the highest proportion of cabinet ministers who have been indicted on corruption crimes in Eastern Europe. More than 1 in 10 of the ministers who've served in government over the last 20 years have stood trial for corruption. However, the conviction rate is exactly zero. Nobody has been convicted in any of these trials. So obviously very modest legal consequences. Now, the other example that I have there as a question mark is post-Maidan Ukraine, where we also have not a lot of legal consequences, but quite a bit of flurry of activity in anti-corruption to sort of precisely achieve this this goal of trying to convince international institutions and organizations that corruption is being tackled. The other possibility, however, is that there could be what I called weaponized legalism happening in the country. So what this means is basically different political competitors are fighting it out through these politically motivated corruption prosecutions. They're trying to marginalize their opponents, weaken them, etc. There is an argument in one of the interpretations of Italy's famous Mani Pulite campaign of the 90s is that it was precisely that, an incidence of weaponized legalism, where basically the political opponents of Christian democracy and the socialists managed through the judicial anti-corruption campaign to basically politically destroy these two parties. It could be also another example of this could be the situation in Ukraine during the Kuchma years, where there were some attempts to fight out political battles in the courts. We remember, of course, Tymoshenko was briefly detained, was about to be charged. It never led to any serious legal consequences because basically Kuchma didn't have the upper hand on the process. So it was sort of a political fight type of situation. The other situation where transparency of the goals of these corruption prosecutions is low, but the consequences are severe, could be sort of a witch hunt situation in which the real goal is suppressing the opposition. It's not really tackling corruption, but it's done very effectively, and there are severe legal consequences. And Russia seems to be a good example of that. For a period of time, Yanukovych seemed to be headed towards achieving that, but I would argue that it's still slightly different, a different situation, because sort of his success wasn't quite as guaranteed as it is in Russia today. Then we have two situations where transparency is high. In other words, these corruption prosecutions are indeed trying to tackle corruption. That's sort of the primary goal here. But depending on how successful these anti-corruption campaigns are, they can be divided into a sort of an inefficient anti-corruption campaign. There's some attempts, but not producing a lot of results through significant legal consequences for the defendants. This is the other interpretation of Italy's Mani Pulite campaign, because if you're familiar with it, thousands of people were charged in the Mani Pulite campaign. That's why it's so well known. It seemed that every day somebody high up in these parties was getting charged with corruption crimes. But at the end of the day, only about 400 out of the 4,000 people received final convictions, and these were all low low-profile sort of scapegoats. So that's the other interpretation of an example. The best example, really, of a successful anti-corruption campaign that we have is Romania in the early 2010s, when the independent specialized anti-corruption prosecution achieved really significant results. So briefly, how do we try to make sense of this variation? And what I want to just point out here is that I would like to call for a more sustained sort of scholarly focus on the prosecution. Courts are mostly reactive in this process of corruption prosecutions. They rule on what they're given by the prosecution. Of course, recent news from the Ukrainian Constitutional Court tells us that courts can be proactive as well. The picture is not so simple, but usually the focus is on courts, and I think it actually should be on the prosecution. And there are two simple institutional hypotheses that are out there that structural insulation of the prosecution from the executive may lead to more transparent prosecutions, and a specialized corruption prosecution may lead to more effective prosecutions. But in fact, these simple and intuitive institutional hypotheses are not supported by some of the crucial cases. These conditions are neither necessary nor sufficient. I have a lot of evidence that from the Romanian and Bulgarian cases, which I won't go into, but the simple story is that the Romanian prosecution, which achieved a lot more than the Bulgarian prosecution, was in fact less insulated from the executive. It was in fact eventually sort of beheaded by the executive in 2018. And the Bulgarian specialized independent prosecution didn't actually achieve anything. So what do I have in mind as how to square this circle? I think we really need sort of a path-dependent explanation here, which gets at what I would call the paradox of the successful anti-corruption campaign. What you need to have this successful anti-corruption campaign is a reformist at the helm of the prosecution. That's crucial to both transparency and effectiveness. However, timing is really essential here. A reformist can make it to the top of the prosecution only if politicians actually think that the prosecution is weak, toothless, and cannot be dangerous. If the prosecution is already strengthened and perceived as strong and powerful because of the institutional setup, politicians will install someone that they can collude with, not a reformist. Then strengthening the prosecution is actually counterproductive to transparency. So you have to start with a weak prosecution and a reformist, with a reformist at the helm of it, and then hope for the best, hope that they can achieve strengthening while they're pursuing an earnest anti-corruption campaign. Happened in Romania, not clear that it can be easily replicated. And I'll end there.
Okay, thank you. Also fascinating material. Our next speaker is David Zaccone, who is Assistant Professor of Political Science at George Washington University. His topic is Russia's unexpected anti-corruption enforcement. And just before I turn the floor over to David, let me remind people that I'm in the process of taking questions. So please send them either to me or to the chat or to everyone via the chat. And I will relay them to the presenters after David's presentation. So David, please take it away.
Great. Thanks so much for hosting this really interesting event. And all of the presentations so far have been really interesting, and hopefully I can contribute something to the conversation. I'm going to be talking today. Let me share my screen. Hopefully that works. Looks like it. About Russia's anti-corruption campaign/reform that's undertaken in some seriousness since 2008, since President Medvedev came to power. And I'm going to be drawing on some research in a paper that's under review right now. So I won't go into too much of the nitty-gritty of the empirics and the quantitative data behind it, and kind of talk more big picture what I think the paper says about the way that this anti-corruption campaign has been rolled out in Russia and what we might expect going forward. So I want to kind of start off with what people usually think about when they think of anti-corruption in Russia, which is, drones flying over oligarchs' houses out in western Moscow in the suburbs, or in Sochi, or in like prime lake spots, and then really flashy, well done, provocative, effective videos and investigations from the Fund for the Fight Against Corruption, by Alexei Navalny, and also cutting edge investigative journalism by Ivan Golunov into the funeral home industry in Moscow. So when we think of anti-corruption in Russia, we generally think of civil society activists, we think of journalists, we think of opposition politicians, peeling back the curtain on nefarious activity and putting these really, really well done and polished exposés out in the public sphere. And then sometimes, and sometimes not, the Russian government will react to these accusations and potentially investigate some of the people that have been accused of wrongdoing. My paper is not about these type of investigations. I think they're extremely worthwhile and they play a critical role in uncovering corruption, but they're only part of what you would need necessarily to tackle the scale of corruption in Russia. And right now, what I think is potentially needs more attention, and I think only a small group of people are actually trying to focus the spotlight on, are the boring documentation that undergirds a lot of corrupt activity in Russia. And in this case, I'm going to talk about income and asset disclosures. So since 2008, most Russian officials, we kind of estimate between 500,000 and 1 million officials every year submit forms to their superiors about the income and assets that they, their wives, and their immediate family members earned in the last calendar year. So here's an example in English. I've translated it for a member of the Council of the People's Deputies for Kyrgyzstan. So she's just a член муниципального совета. She's kind of a low-level but elected official. This is her asset and income disclosure for 2016. You can see that her husband drives a Volkswagen Polo. Collectively, they have about 1 million rubles in income for the last calendar year, and they have one apartment that's shared among their family of 4. So what's interesting about these income and asset disclosures is that my research finds that they have a pretty strong effect on important political outcomes at the local level in Russia. And I think that's what's unexpected about this. So a lot of people think that these politicians are lying on the forms, that they disappear into a rabbit hole of bureaucracy, nothing ever happens to them, and they're so far from reality that how could they actually change the way the politics works on the ground? And I share that skepticism, but I think the empirical analysis has shown something different. Just real quick, big picture, why would we be interested in this question? Well, it's not just in Russia that anti-corruption campaigns and reforms are being rolled out with great fanfare. If anything, this is kind of a cross-national wave in the last 10 years of a big country with potentially lots of corruption going on, understanding that, they need to do something, or there could be protests, there could be quote-unquote color revolution, there could be international pressure. Lose out on economic growth if they don't do something. So, China's embarked on this really ambitious Tiger and Flies campaign under Xi with varying success. There's that high-profile Saudi crackdown on the princes in the hotel in 2017. So, there's a lot of this stuff going on, but we don't have a real good theoretical understanding. I think Maria's presentation got us a good amount of why would different countries adopt different approaches to going after corruption, and what might explain the variation in effectiveness. Now, all that said, there's a lot of reasons to be skeptical, especially authoritarian regimes claiming that they're going after corruption. And, Russia is parcel of this. And it's a good example of why people really brush this stuff off and saying, why we spend a lot of time looking at the official anti-corruption campaign, because there's so many reasons to be skeptical. it's really ripe for political manipulation. Anti-corruption campaigns can be used to go after your rivals. I mean, Navalny has been blocked from running for office because of supposedly an anti-corruption or anti-fraud campaign being used strategically against him. So, there's a lot of reason to think that this is not going to be evenly rolled out across the country. It could be really shallow PR exercises. I think few believe that the drain the swamp rhetoric in DC, where I'm currently at, is anything more than just an appeal to voters. Like, if anything, the situation has gotten worse the last 4 years. So, I mean, there's a lot of public perceptions that might benefit from going after corruption, but that doesn't mean you're doing anything on the ground. And then also, a lot of these regimes, especially Russia, they're dependent on some kind of corrupt flows going up and down the ladder to keep people loyal to the regime. So if you go after certain people and start to cut off rent seeking, you can upset a pretty fragile government arrangement. So why rock the boat necessarily? But, I mean, these are all reasons to think that anti-corruption reforms from an authoritarian government are not necessarily going to be effective. Just like I'm going to show something different today, and specifics are an opinion I'm happy to distribute afterwards, and the memo will also describe it succinctly. But the argument is that anti-corruption reforms can really seriously affect selection into political office. And I look at this by examining financial disclosures, which are probably the most common anti-corruption reform in countries worldwide. And I guess 161 out of 175 countries, according to the World Bank, have some type of income and asset disclosure law, like the one I described in Russia, on the books. So this is something that international organizations always prescribed. It was a near first step to try to put a country's government in order. What I'm going to do is analyze the gradual rollout of this law in Russia. And what's interesting is that Russia didn't come out with a big bang in 2008. They strengthened it over time, and because they changed different aspects of the law in basically 2-year intervals from 2008 to 2000, basically they're still changing it right now. You can do some before and after analysis and see the type of people that run for office before the law is passed and then after the law is passed. And that generates these kind of interesting findings that after they put in a more transparent regime, after they required officials to fill out forms about their income and assets and cars and bank accounts and all that stuff, you have a lot of incumbents leave office. About 25% of incumbents at the municipal level did not run for re-election in anticipation of the fact that the next year, if they would win, they would have to reveal this information about their finances. So you get a lot of turnover, which I think is interesting because you're getting new faces in government, you're getting younger people coming in, and so forth. So the disclosure laws are doing something in terms of changing the makeup at the municipal level. The second is a look at who are the type of people that are going to be most worried about their finances coming to light. And I make this argument that there's lots of different people that are making money on the side and maybe not declaring it on the tax forms. You could have teachers that are accepting bribes or doing after-school tutoring. You could have the guy at the DMV accepting some money under the table to give a license. But they might have political connections, or they might be so small scale that even a disclosure form is not going to uncover any type of anomalies. What I do argue is that there's a group of people in Russia, small businesses, that are historically associated with lots of tax evasion, have a much longer formal paper trail where they can't completely falsify all of their records, and that there's just a lot of more documentation for prosecutors who get the disclosure form and try to verify it against lots of other openly available data in Russian society, whether it be the tax office or the Gibet to look at their cars or to look at the cadasters and see if the properties actually match up. That these small business owners, individual entrepreneurs, because they're kind of focused on the cash economy, they're going to be especially deterred by a disclosure law and not want to run for office because of the transparency that is going to be imposed on them and potentially some of the tax evasion or skeletons in their closet coming out into the open. And I think the last argument of the paper is that all of these effects, you get more turnover, you get more reticence among small business people to run for office in regions where law enforcement capacity is higher and independent media is stronger. So it's kind of just a simple interactive effect. But I use lots of different measures of how many prosecutors are actually going after these officials? How are they processing the data? How many audits they, administering every year at the regional level? And then what kind of independent newspapers are active, or even websites to look at this stuff? And you see when law enforcement capacity is higher and independent media is higher, the disclosures produce larger effects on political selection. So that's the paper in the nutshell. I'll talk a little bit about how I get to those conclusions now, and then kind of end up with a couple future projects and what this all means. So, like I said, this campaign has been began in earnest under Medvedev in 2008. It's not just income and asset disclosures. There's a couple new anti-corruption bodies. This Kdac has a much more broader anti-corruption mandate than it did before. And there's, reforms to public procurement. This is not as comprehensive as most people want from the Russian government, but it's not nothing. And I think we need to sometimes treat this stuff more seriously and not just dismiss it. What's interesting, in 2008, for the disclosures, they posted on all federal officials, the Prime Minister, the President, the Duma members, and then regional legislatures and full-time municipal deputies. So only a fraction of municipal council members are paid for their work, and they were caught under the law in 2008. Now, the first 5 years were pretty chaotic with the way that this reform was rolled out. Every report was published online, and a lot of regional legislatures pushed back. They just didn't want the quote-unquote intrusiveness, and they said, why do I have to report? This is a very cumbersome law that is creating problems for me. So the federal government was a little bit embarrassed by the fact that it had this big anti-corruption reform, but a lot of the people at the lower levels weren't complying. So in 2015, they enacted stricter sanctions, saying that if you don't submit your form every year by April 1st, or if we find problems in that form, you can be immediately removed from office by the prosecutor's office and potentially jailed. I see Henry here, so I will go quicker. And the bigger thing is that they included a bunch of municipal deputies for the first time under the law. So this is a new group of elected officials that have been brought under the disclosures law for the first time. What I do is basically a before and after type of comparison of what kind of people ran for office before the law was passed and what kind of people ran afterwards, and that's where I get the big effects. So again, I can share paper to show the statistics. But in general, like I said, we get these really strong effects of political selection among incumbents and individual entrepreneurs. With a couple of interesting things. One, this doesn't just affect United Russia deputies, that it's less a political purge of opposition more than a blanket dictate, that you see almost equal numbers of United Russia and opposition deputies leaving office and not running again because of the ethics mandate that's coming into force the next year. So I can't say that the anti-corruption campaign has actually reduced corruption. We need more data on that, and a lot of the data is dependent on the forms. But I can say that it's increasing the cost of engaging in corruption. That if you want to run for office at the local level in Russia, you need to put those assets in your cousin's name or an offshore company. You need to create some distance, because it does look like prosecutors' offices are doing a pretty decent job in some cases of verifying the information you put in them and holding you account. And I've got hundreds and hundreds of cases of people actually being removed from office by the local prosecutor's office because of the information in their forms. So this information is out there, and people are reacting to it, and they actually are tweaking the law because there's a lot of anger among deputies the way that it's being rolled out. And then the other big thing is, when do such reforms work as intended? Well, in this case, it's not voters that are voting out these deputies. A lot of times elections happen 3 or 4 years after the disclosures are first submitted to the public. It's really journalists and law enforcement that I find a lot of anecdotal evidence, but also statistical evidence, that they're the ones that are analyzing the forms and bringing cases and drawing attention to this and actually getting people removed from office in the thousands. And I think that's this surprising aspect of this campaign, that there are people being punished at the local levels because of these kind of boring disclosure forms. Now, I don't think this is going to be the case at the higher level, and I'm happy to talk in the Q&A about why Kadyrov and a lot of other people who have had these discrepancies uncovered have not been brought to justice. I think this is a specific campaign to clean up the highly visible, low-level officialdom and make it seem like the regime is taking action against corruption in its ranks. So thank you very much, and I look forward to your questions.
Okay, thank you very much. I think that includes 4 very interesting presentations. So I encourage everybody to continue sending me your questions, or send them to everybody. Let me just start with a round of questions. We'll just go in the order that people spoke. So we'll start with Emil. And so I'll pose one question to everyone. And so for Emil, let me give you a question from Sharon Rivera, who asks, how important is the personal factor in the emergence of the Constitutional Chamber as a fledgling guardian of democracy? Can you explain how the open, transparent selection process that you mentioned led to the appointment of judges with both the political will and the expertise to change the way the chamber operates? For Ron, there's a question about just, how do we make sense of this, right? It's really interesting. It seems to be that the courts are supposed to be, on one hand, courts are supposed to be independent, but at the same time, when they're acting in independent ways, this breeds mistrust. And I assume that the reason that this is mistrustful is that people think the courts have some kind of political agenda or economic agenda, maybe, as opposed to ruling, impartially, right? The difference between impartial and independent. But how do you get there? How do you get from independent to impartiality? Don't you have to pass that first stage first? But if this undermines trust, I mean, Maria's also written about that, then, how do you wind up making that transition? Then for Maria, actually, I'd kind of like to just ask Maria and David to comment basically on each other's presentations. But just let me frame the question this way, in that both David and Maria, it seems like, if I'm interpreting you correctly, neither of you treat Russian anti-corruption efforts, at least the one you're focused on, as purely Potemkin corruptions or Potemkin prosecutions. Maria sees a witch hunt. That seems to be how Russia was classified there. Whereas David, you seem to, correct me if I'm wrong, but you seem to interpret this as a genuine effort of some kind to curb corruption, right? Like in the slot and implications, you mentioned reforms working as intended. So I wonder if you could comment, is my interpretation correct? Why don't you see these as showboating, kind of Potemkin prosecutions? And what about a third possibility, the possibility that a lot of these prosecutions, and including the adoption of these reporting laws, has a lot to do with being able to demonstratively punish a few people, or at least kind of put them on the hook for such punishment in order to prevent defections, to demonstrate the credibility of of threats by the regime to do bad things, even to some of their allies. So let me just turn things back to the speakers, and we'll have another round of questions. So again, please urge you to invite you to send your questions. So first, Emil.
Yes, thank you very much, to Sharon and Henry. This a few now nuances, right? Since the chamber started working in 2013, up to now, there has been a dynamic process for the court, for the chamber. It's been changing both in terms of the judges sitting, or many of the judges who came to in the inaugural cast of the judges have left because of the 7-year term limit for the initial term, and then several of the judges had the longer term. Several, the very first judges had this term of 7 years. Now, the personal factor was very important indeed, and it was possible for this institution, at least compared to relative to what it used to be and what it is generally with judge appointments, to gain a much greater transparency as to their backgrounds, as to their competency in terms of legal expertise, and if they had judge experience as being judges, which they did not have to have, then how they were judging. Now, of course, the vetting process is by far not as intense and as scrutinous as it would be in, for example, the United States, whatever we saw in the recent years, most recently with Judge Barrett. Now, in Kyrgyzstan, the primary process of vetting and testing and attestation has been carried out by a national council on the selection of judges, specifically set up institution to recruit and to vet judges. And then the judges go through further vetting and interviewing, questioning both by the president, and finally the confirmation is done by the parliament. Now, what has been happening very troublingly, unfortunately, when I call it fledgling guardianship of the constitutional court of democracy, it's been a process by which more and more new appointments were possible to politically tailor in a certain direction, in Ivan's language, in a simple politicization process of the constitutional chamber. Most recently, 3/4 of the original judges leaving the court and being filled back with mostly prior former judges, whereas the initial cast had actually many judges who did not have judging experience, but rather were legal counselors, lawyers, rights activists, teachers, academics, etc. Now, one possibility for still maintain the scrutiny and the rigor for the constitutional chamber judges is the transparency of their decisions and the precedent of how the chamber has been arguing and reasoning in its decisions every time, so that overtly or runaway political sort of decision making or rubber stamping is just not possible, because you have to provide the arguments. And on that basis, keeping on that sort of possibility, I argue it should be very urgent to maintain the role of the constitutional chamber that has been charted out at the very beginning. But indeed, it's a very important question, and notably, of course, none of the former top judges from both the Supreme Court or the Constitutional Court, previous one, came to be considered for the new chamber.
Okay, thank you. Ivan.
Okay, Henry, actually the question you asked is a $1 billion question. And I would argue that actually, you see, there is the relations between two notions you use, the impartiality and the independence, is quite complex. Because actually, I mean, independence is not a necessary cause for impartiality. So the problem is that actually, and I will link my answer to what Emil has just said, vetting is an important part of making judges impartial, because you have actually to control, to probe into their interests, to check whether there is a conflict, and to try to build in some constraints for them, let's say, making rulings in their own political, social, or economic interest. And the problem is, it's like, I just want to go back to the idea I was trying to present, is that a High Council of Justice is actually constituted just to do that, to vet judges, to remove those who are not, let's say, working correctly. And it has been partially hijacked. So the response is go back to re-elect the High Council of Justice and to reinstall it with people who have no conflicts, who are not clients or allies of judges like those from Kdac, and leave them space to do their work. So, I mean, you need some institutional constraints. They are there now, but you have to make them working properly. That is the issue. Thank you.
Thank you. Thank you. Maria.
Hi. Okay. So I suspect David and I actually don't necessarily disagree here, but the difference is that I was talking about high-level, sort of the tackling of high-level corruption, and he's mostly focusing on the lower echelons of power, and perhaps. But it's an interesting point that none of us actually see it as this showboating, and I think maybe witch hunt. I'll have to think about whether I want to call it a witch hunt. But the reason I don't see it as a Potemkin village is because it doesn't actually. It's not. I don't think it's aimed at the high level prosecutions. I don't think are aimed at sort of showing anyone, definitely not showing the international community that Russia is prosecuting corruption. It's more likely sort of the difference between sort of a weaponized legalism situation where it's a, that's why I don't want to call it weaponized legalism when it's different factions sort of battling it out in the courts. Because clearly, I think in high level prosecutions, the Russian regime has the a clear upper hand. But it is very close to what you're. I would agree with your description of it as being a mechanism for sort of managing your authoritarian coalition. So. It's maybe not necessarily a witch hunt, but it's still sort of selective, targeted use of corruption laws to actually achieve political goals. So I'll leave it at that.
Terrific, thank you. David.
Sure, I think there are two questions. So, and Maria, I agree. There's huge differences between high level and low level corruption, and I think your explanations are very interesting, and I think are going to uncover a lot of interesting insights on how that works. My one feedback would be whether or not transparency and then so-called effective investigations are orthogonal to each other, like, because it does seem for my work actually really important for increasing effectiveness and seriousness of the investigation. So you might want to think about whether or not what is the intermediating factor and what is the actual outcome. The more transparent things are, the better they seem to work in Russia. And then the other thing about Henry for the defections, I do think that this reform is designed to strengthen the government's image and improve the ruling party effectiveness after a lot of complaints. There is probably some aspect of it to prevent defections, but I think in general, United Russia is really unwieldy, and we know that Russia is huge, and it's all the organizations dispersed across the entire country. This bring all that together in a little bit and empower local actors to go after the worst offenders in their area, and maybe make United Russia have a different public face. In the regions, in the villages, and in some of these really small places, rather than them necessarily worried about some guy in Khabarovsk defecting. They're probably more concerned about defections in the center.
Okay, great. So we have about 10 more minutes left for questions. Actually, a whole stream of questions came in. So what I am going to suggest is I'm just going to kind of give the questions that we have now. It's about one each for Emil, Ivan, and Maria, and then a bunch for David. And I think he may have fatherhood duties that may be calling, so we'll see how much he can get to. So just very briefly then, for Emil, it's a question from Alexei Trochev, also one of the great experts in this field. And he asks, does social support for the Constitutional Chamber exist outside of Bishkek? If people can rebel successfully, why would they accept a Constitutional Chamber's decision? And also from Alexei for Ivan, how is complex politicization of the court different from the capture of this court? For Maria, there are actually a couple questions. One from Alexei, who just notes, I guess for your comment, that the intention to fight corruption seems to be a precondition for transparency, while legal consequences seem to be dependent on the text of the law, such as the criminal code. So maybe if you have time to comment on that. And then Peter Rutland asks you to comment on work by Martin Mendelsky, who is critical of the Romanian campaign, Peter says. So he asks basically, do you agree with this analysis? So for David, maybe in the interest of time, let me just ask primarily a question from Gulnaz Sharafdinova, which is the resulting reticence to run for office by small business owners a good thing, in combination with Alexei's observation that Russians tend to learn how to go around the law for lots of things? So is that likely to be happening here? He also notes that information about assets may be very valuable for Siloviki. So let's leave it there, and if we do have time, I'll come back to the remaining questions for David. But since maybe let me just see. I mean, David, would you prefer to go first or last?
I think I'd prefer to go first.
Okay, so why don't you go first? Yeah.
Sure, I'll be really
We'll go in
quick.
reverse order, sorry. And so we'll go then from David to Maria, Ivan, then Emil.
Sounds good. Yeah, Kunlas, I'm not sure if it's a good thing. I think we do need some level of business representation in these councils. They have a fair amount of power. They have a decent sized budget. I think it's, a lot of people malign the municipal councils as doing nothing. And I think there's more evidence that they are more actively involved in, especially in the environment and some kind of construction and land permits. So removing all business people and making it just a bunch of bureaucrats that are sitting there because nobody else wants these positions is not great. But I do think that the more competition, the more interest in municipal councils, the more democratic participation is a better outcome. And I think part of getting some of those incumbents out of there produces more engagement, I would think, potentially, and more interest in getting involved in politics across the entire country. And if the disclosures lead to that outcome, I think they probably are a step forward.
Okay, great, thanks. So Maria.
Thanks for the interesting questions. I'll start with Peter's question. Yeah, I've read Martin Mendelski's work, and I disagree with his assessment. He basically but in any case, even if he is completely right, his point is actually moot to my argument, because what he is claiming is that the Romanian prosecution went too far. It became overzealous and prosecuted some innocent people. He doesn't necessarily have very good evidence of that, but in any case, it's a moot point. Because here, what I'm interested in is sort of why do we get an earnest attempt by a strong prosecution to try to tackle corruption. The question of why might they go too far is sort of separate if they've gone too far. Now, Alexei's point about transparency and the severity of consequences, sort of depending on very different things, is well taken. On the severity of consequences, yes, the legal code may matter, but I'm also talking about whether cases will be opened. Maybe there's a potential for conviction, but that potential is not fulfilled. So there's no legal consequences because everybody gets acquitted, regardless of what the law actually says. So, but definitely something to think more about. And also David's comment about transparency and effectiveness being orthogonal. For sure, I would need to flesh this out more. Thanks.
Okay, terrific. Ivan.
Okay, well, I start with the level of semantics. So how and why should we differentiate the capture, the word capture and the word complex politicization? The word, I mean, because when you use the word capture, and now I'm on the semantics level, it is about seizing, it is about making captives. The idea is that some malicious forces from outside, they come and they take control over something. And here, why I think that the last, let's say, charged word is important and significant is because here you have like people who work here in the institution, they're judges, they appropriate it. So if you want, it's better to use the word appropriation by locals than the capture. And secondly, and it is not on the level of semantics, but on the level of the argumentation, I wanted actually to make and to emphasize that you cannot capture any card. And I mean that complex politicization, it has some structural prerequisites. What am I trying to tell is that, you know, for instance, you can try and you might capture, let's say, some appellate court. You can try and capture some court in Vinnytsia, local regional center in Ukraine. And it will make no, let's say, much, it will not have much of strategic use. Politicization, and when it is complex, it is more about structural prerequisites plus internal dynamics within the body governed by some people, by actors. So I would argue that it is more appropriate to the situation. Not a simple capture, which is coming from outside, but something much more complex. Sorry for tautology, complex.
Great. Now, Emil.
Yeah, a great question, Alexei. And I think Alexei, at least one chapter by Alexei himself partly would answer this. Now, the mobs have had some experience storming into the Supreme Court of the Kyrgyz Republic and getting certain decisions basically by wringing their hands back. In Kyrgyzstan, I think whenever we are seeing times like this, as in the last 1 month, I think, of course, the courts are not able to fully independently and impartially decide whatever comes their way. Now, not impartially, but independently, let me say. But the chamber's chance to pass a fair decision, the right constitutional decision, and have that decision hold, of course, depends on the stabilization, on pacification of the political tempo in Kyrgyzstan. But the constitutional chamber of Kyrgyzstan is possibly the least known for the general public. Indeed, actually, looking at Ivan's chart on the popularity or distrust level of toward the courts, I was thinking actually to myself whether when people respond with their distrust scores towards courts, they actually identify any specific course, or they just give the scores based on the courts that they know most, which tend to be usually the lowest level first instance courts. Criminal courts, etc. But constitutional chambers, probably most people don't even know. But what really is what matters for the constitutional court, especially as the case, the present case comes to it, is really how the leadership, the political leadership, de facto leadership, the parliament, Sadir Japarov and people like that, go with it and what they do with it. Not so much what the masses on the streets would be doing it now. But generally, the one major remaining issue for the constitutional chamber has been, of course, how the other chambers, especially the parliament, but also the executive, follow up and comply with the decisions of the constitutional chamber, especially when those decisions require them to take action. But in this case, with such a high stakes situation, there's a bit of a similarity to 2010, somewhat of a balance, where Sadir Japarov, 2 weeks ago, highly dominant on the playing field, has now been increasingly coming to a situation where he has to cave in, where he has to compromise. And in this situation, the Constitutional Chamber's decision, one way or the other, but I hope, of course, one way, does have a chance of affecting where the events unfold. Thank you.
Okay, well, thank you very much for a set of really interesting presentations. We were not able to get to all the questions today. I think that's one sign of a lively conversation, unfortunately, in our limited time. Let me just invite everybody to our next session, which we're going to be doing at a different time. It'll be at 10 a.m. Well, actually, I guess it is the same time, isn't it? So 10 a.m. to 11:30, but it'll be different in that we're partnering with the Harriman Institute at Columbia University and the Jordan Center at NYU to have an event on U.S.-Russia relations after the U.S. elections. What can we expect? So we'll have Moldovan foreign minister previously, Nicu Popescu, talking, as well as Sam Green from London, Maria Snegovaya from the U.S., Andrei Kartunov, and Victoria Zhuravlyova from Russia. So it should be a variety of different perspectives. We'll be talking about it, even if we don't know the outcome of the election, which I think we'll all be following closely. But thank you once again to our speakers and to all of you for attending and contributing to the event. And hope to see you again soon. Thank you. Bye.
Thank you.